Good morning to everyone at today's public hearing of the Vetting Commission established under Law Number 65 on the external evaluation of judges and candidates for judges of the Supreme Court of Justice. I'm Scott Bales, the chair of the commission, and I declare this session open. The hearing is being conducted under the Commission's rules of organization and functioning as part of the evaluation process. The subject of today's hearing is Vladimir Adam, a candidate for the position of judge on the Supreme Court of Justice. Mr. Adam is a prosecutor at the Anti-Corruption Prosecutor Office. Mr. Adam, welcome. Buenos I'm joined by 5 other commission members. To my left is Vice Chair Andre Bevel and commission members Lavle Perling and Yuri Gatskin. To my right are commission members Lillian Ansu and William Brower. The Commission is also assisted by members of its secretariat. You may notice also that in our room today there are some representatives of the public and possibly the media. The photographer will be taking photographs briefly just at the start of the hearing. The hearing will be conducted with interpretation between Romanian and English. To allow for accurate interpretation, I ask everyone to speak clearly and slowly. Only one person should speak at a time. The proceedings are being recorded. The recordings of the Commission's public hearings generally will be available online at the Commission's website, www.vettingmd.eu, within 3 days after today's hearing. Mr. Adam, during the hearing, one or more members of the Commission may put questions to you. It's important that you answer them truthfully and completely. Your answers are important to the Commission's evaluation of your financial and ethical integrity. At the end of the hearing, you'll be given an opportunity to make a brief closing statement. In posing questions, we will take into account your privacy and, where appropriate, the privacy of family members and other close persons. So we will try to avoid referring to things like specific ID numbers, real estate addresses, bank account numbers, that sort of thing. We'd ask you to do so similarly for the protection of privacy. I will start by briefly reviewing the evaluation process for Mr. Vladimir Adam. The Commission initiated its evaluation on February 15th, 2024 by notifying him by email and asking him to complete and return an ethics questionnaire and the financial declarations required by Law Number 65, the year 2023. Mr. Adam returned the completed declarations and questionnaire on the 23rd of February, 2024. As part of evaluating a subject's ethical and financial integrity, the Commission also obtains information from many other sources, such as the National Integrity Authority, the State Fiscal Service, the General Inspectorate of the Border Police, other public institutions, financial institutions, and open sources. The Commission assesses the information it obtains for its relevance and reliability. On the 10th of May 2024, the Commission asked Mr. Adam to provide additional information by May 20th to clarify certain matters. He provided answers and documents by the designated date. On the 18th of June 2024, the Commission asked him to provide additional information by June 25th to clarify certain matters. He provided answers and documents by that date. On the 25th of July, the Commission asked Mr. Adam to provide additional information by August 4th to clarify additional matters. He provided answers and documents on the 4th of August 2024. On the 6th of September 2024, we notified Mr. Adam that the Commission in its investigation had identified some areas of doubt about his compliance with the ethical and financial criteria. We also invited him to attend today's hearing. Mr. Adam, do you wish to make any corrections or additions to the answers you've previously provided to the Commission in its request for information?
Sure. Of course.
What particular corrections do you wish to make?
Chairman, members of the Commission, being a servant in the prosecutor's office for 24 years, when I was informed that there was this competition to take part, to become a judge in the Supreme Court of Justice. Looking back at my experience, at my qualification years, and taking into account the fact that my activities were related to the judiciary sector, both civil and economic law. And during the last 15 years, I've focused on criminal law aspects related to the judgment of criminal cases in courts. And before taking over the position of prosecutor at the anti-procuration prosecutor's office, I worked in a section department of unification in the general prosecutor's office, focused on examining criminal cases in courts. I totally agree with you that during the assessment, I filled in the application together with the documents in February 2024. I've filled out a questionnaire. Well, the questionnaire, the ethics questionnaire, and by that I've tried to be fair, correct, and to answer to all the questions included in that questionnaire. Obviously, through all the answers, because there have been 3 rounds of questions, and I actually support what you've said, because after I received the questions, I tried to answer briefly and exactly to everything that the Commission asked. Some uncertainties were revealed or raised related to my statements in those questionnaires. Therefore, Chairman and members of the Commission, I'm open to cooperate with you and fully seriously and honestly I could answer to all the questions that will come from your side during the audience, the hearing. So I submitted the answers within a deadline, 25th May 2024, February 2024, in August, 4th of August 2024. Obviously, I've looked into the provisions of the law. 252, I know about the consequences deriving from the evaluation of my activity if there are some gaps identified that would raise some doubts or areas of doubts in terms of my integrity or activity as a prosecutor.
Mr. Adam, we'll come to some follow-up questions about the identified areas of concern. What I want to be clear on, though, is you're correct to note that you submitted answers to 3 rounds of questions. But if you, sitting here today, know that your answers to the last round of questions are in some way incorrect and you want to correct them, that's what I'm asking you at the outset. Is there anything that you think now was in your answers that was inaccurate?
Desigur.
Of course. Honorable members of the Commission, during my analysis of the doubts raised by the Commission, which are the following, there are some discrepancies between incomes and expenses for the year 2014, 2015, 17, 2020, 2021, and 2022. Basically, in the 3rd round of questions, I had the same questions coming to me. In 2nd round, I answered to those questions, and basically, I've expressed my stance, in relation to the objections of the Commission. More specifically, for 2014, Initially, the Commission has established an inflow of income minus 83,000 lei and more, which basically till August 23 it was reduced, and in the presentation of doubts this amount was diminished and arriving to the amount of minus 26,484 lei. So I've tried to be objective and correct in answering to all the questions you've raised. I want you to take into account the fact that those questions look at the period 2012-2024. So it's not so easy to remember exactly all the expenses and all the incomes that we've had in that period. I've indicated in my round of questions in my first round of questions, it was this question: Madam, Mr. Adam, what savings did you have during the years 2012, 13, and so on? So I've drafted my answer, and given that there was a long period of time passing by, I said I did not know exactly what was the amount of funds in my family. During this time period, I've presented you my experience and my documents from my activity, different bank statements related to my bank accounts and my family bank accounts. So I had two bank accounts that were open at Moldova Growing Bank in Moldova. So starting from 2017, I've presented the bank statements that included the salaries I had during my activity. Honorable members of the Commission, obviously I have a specific age. I'm almost 6 years old. So I told you already about my experience in the law enforcement bodies, in the prosecutor's office, and basically when the law on declaring the assets in 2011 was put in force, I've been working in that time since 1990s. So I had a specific activity already before that. My wife is working in public sector too. I have a child. I did not have some investments during the years, no real estate, no houses, no funds coming from abroad. I've indicated I had to have two citizenship, Moldovan and Romanian. Maybe you already had a chance to check all the assets that I might have all around. So now I want to talk about the year 2014.
Let me interrupt, if I may, because I think we may not be understanding each other. We understand that you've provided in your answers explanations for the identified concerns the Commission raised. What I'm asking right now is if you have anything in addition to the answers you've provided previously. So I'm not asking you to tell us again what you said, for example, in response to the second round of questions. I just want to make sure that what you've told us is what you now believe. Do you understand?
Honorable members of the Commission, everything is true, and I can bring evidence in this regard. There was the version of the Commission. I've expressed you my version. I've told you that my version is different from the Commission's one, and I want you to take this into consideration. But it's not that this is not so simple. We had different procedures in place. I've accepted your calculation procedure, because what I've indicated in the second round and third round sorry, second round of question, and basically I made all my best to remember the savings I had during all the years, the money that were on my accounts in 2011, 12, 13, 14, and so on. I presented everything, all the turnover I had on my accounts and my family had in that respective period. The Commission looked also at some amounts that were excluded from the incomes because they were received before that. So I'd like to the Commission to take into consideration that I did not hide anything, and the incomes I've indicated are real. There might be some gaps, of course. Why did you fail to indicate a donation contract or a specific amount of money? But every situation should be looked in relation to the context at that time, because it's some traditions that in Moldova we cannot avoid.
All right, well, we'll ask some follow-up questions. And again, I just, let's make clear we're talking about the same thing. I've understood you to say that you've provided in your answers to the additional rounds of questions your explanations. All I'm asking right now is whether there's anything about your prior answers that you today want to correct. I think you said that what you've said previously is accurate. Is that true?
Of course, yes.
Now, with regard to your ethics questionnaire that was submitted on the 23rd of February, 24, is that, in your view, still accurate as of today?
Totally correct.
Okay. Now we'll ask follow-up questions, and we'll try to keep our answers short and to the point, and we'd ask that you keep your answers short and to the point as well. And as I said, you'll be allowed, before we conclude the hearing, to make a statement if you'd like to make an additional statement in response to your answers to our questions, okay? Okay. Now, as you've already alluded to, in the hearing notice, we identify various areas of concern. 6 of the areas of concern questions about inexplicable wealth, about an identified difference between cash expenditures and cash outflows. So we'll talk about some of those issues. There are another 6 issues that relate to non-disclosures of different kinds. And then finally, the last issue is one that relates to the undervaluation of the purchase price for a car that you bought. So we may not ask specific questions about each of those issues, but that's the range of issues that we're talking about. Now, first, I want to go back to the year 2014 and the issues about inexplicable wealth. In follow-up answers to the Commission's questions, you noted with regard to the year 2014 and also with regard to the later years, 2021 and 2022, that you had received birthday gifts in those years of amounts that range from $90,000 in 2014 to $20,000 in 2021, $50,000 in 2022. None of those gifts were identified in your NIA declarations. Why did you not disclose them?
Honorable members, if I would look back at the law on integrity that was that entered in force in 2011, basically during the applicability of this law, a series of amendments were introduced. Yes, obviously we had this 90,000 lei that I've indicated in the questionnaire that I submitted to the Commission, and I mentioned that it was an amount that basically 2014 was for my 50 years old birthday. So, of course, I've celebrated this anniversary and I've invited the closest friends according to our traditions. I have got sons, children, different friends across Moldova and abroad who participated in this celebration. So this amount that I've indicated is the amount that I collected at that celebration. And given that in 2014, I was not obliged to declare, because the cash amount started to be declared since 2017, because in August 2016, amendments were operated to the law on declaration of assets. So in the context of that law, I was not obliged, we were obliged that all the amounts going beyond 15 average salaries per economy to be declared to NIA.
I think you're confusing two different things, Mr. Adam. There's a requirement for the declaration of cash, which, as you noted, came into effect after the later amendments, but there's also a requirement for the declaration of income, and that would include donations in this magnitude. So why in 2014 did you not disclose the birthday gifts?
Nu a fost
It was not a gift, 90,000. This was the amount that I collected during my birthday, coming from different people. So I've indicated that I actually had that amount during the activity, but the Commission did not look at it given the provisions in Article 4, which said that this was income and I had to declare. And also in that period, not all the people used to declare the goods or money coming from birthdays. These were not included or subject to declaration.
What is the reason you didn't declare the amounts that you say you received for your birthdays in 2021 and 2022?
Sumele de naștere care le-am primit.
The amounts I received for birthdays in 21 and 22 are not significant and do not reach the threshold of 15 average salaries. That's why I did not indicate it, them, because it's not significant. It's 20,000 lei. I've recalled about these amounts on all the incomes coming into my family in that period. So I've invoked them, but the Commission did not take them into account.
Let's turn to a different issue in 2014. As you know, you received a loan that year of 400,000 Moldovan lei from a bank. In your answers, you've said that you gave from that loan about 60% of the proceeds, or 240,000 lei, to your brother-in-law, Mr. Platon. Why did you...
Cumnatul meu.
Why did you take a loan to give money to your brother-in-law? Why did you do that?
Chairman and members of the Commission, I basically answered already to this question in first, second, and third round of questions. In 2014, as a legal and as a natural person, I've benefited from a loan from Moldova Agrium Bank amounting to 400,000 lei. According to the provisions in the contract, that money was taken for my personal needs, and I've indicated what specific needs I had in the declarations or the questionnaire that was submitted to the Commission. During that time, given the fact that using the money I wanted to change my apartment, but the money were free, was not used, part of the money, specifically the amount of 230,000 lei, because the Commission said about 240. Because the loan was about 393,000 lei, not 400,000.
Let's go back to the question. Why did you loan the money from? Why did you loan the money that you had borrowed from the bank to your brother-in-law?
I did not borrow the money to my brother-in-law, but I've in the interest not of a third person, but of a relative, and taking into account that the money I had or I received as a result of signing that loan contract, I did not use them according to the purpose because I wanted to change my apartment. But later on, the neighbors, we had some misunderstanding with them, so I refused to have this shift or change, and the money I took in cash from the bank was now my asset. Taking into account the relations I mentioned in the questionnaire, the relatives, I had some good relations with my brother-in-law. He needed urgently some money. So as I've indicated to the Commission, I've given the money to him under the provision, provided that the loan would be paid back to the bank and the interest too. I presented to the Commission the turnover of the money from the bank, including the amount I paid and the Platon Andrei.
Okay, let me follow up with some questions related to that. We understand that Mr. Platon paid the bank back portions of the loan. We understand that. Did the bank agree that you could give him the money rather than use it to improve your apartment?
Of course they did, because the bank always accepted the amounts that Platon paid.
Did you have an agreement in writing with Mr. Platon about his repaying the bank the money that you'd given him?
No, we did not have an agreement, given that the loan agreement amounting to 400,000 lei was indicated in the declaration of assets for 2014. Therefore, every year, I used to repeat this loan contract. And in that sense, I've also consulted members or people that I've worked with previously, and they were working at the National Integrity Agency, and they said this was not your risk. Because before getting the loan, I've guaranteed the credit, the loan with the mortgage. So if I would not repay the loan, the bank would take the asset that I use as a guarantee.
Right. So I understand from your answer that you did not have a written agreement with Mr. Platon. Da? Okay. You mentioned that the loan had been secured by a mortgage. There was also a suretyship agreement. Your wife signed a suretyship. Did she agree that the money could be given to her brother-in-law and he would repay the bank?
Of course I was sure, because during the years, my brother-in-law, who is also almost 50 years old, we developed with him close relationships, and I never had doubts about his honesty.
Well, again, my question specifically was, did your wife agree to the arrangement you had made with Mr. Platon?
My wife agreed, yes, of course, because it's her brother. And basically, when we signed the loan agreement, she agreed to use as a guaranteed mortgage this asset we had the ownership.
And I assume that her agreement was also not written. Is that correct?
Her agreement, yes, she did know that from that amount her brother would benefit, but she was not obliged to give her written consent. It was just a verbal transaction between me and my brother-in-law, because I had that obligation towards the bank, because the risk was on me. If Platon was not to pay back the loan or the money I gave him, I was to pay back with the mortgage, the asset I used as a guarantee. So I want to make one mention. I worked a lot on this, the documents. I don't know if you had the possibility to look at, but I presented to you all the turnover on all my bank accounts. And you already know from the data I presented to you that I have good experience and a specific background. And the provisions of the contract included a 10 years period. And I think I paid more than 5,000 lei, and according to the repayment of the loan, the amount would reduce. So with my wife, I had a salary that was 6 times higher than the loan, the installment I had to pay. Honestly, I stayed a whole night to calculate the money Platon paid back and the money I paid back. Every month he used to pay an amount of 5,000 lei. Basically, I could afford this responsibility of 5,000 lei, but I tried to be honest in front of the commission. I've explained how Mr. Platon appeared in the list of people that paid a part of the amount, the loan I took.
Do you know where Mr. Platon got the money that he used to pay you back?
Yes, of course. I mentioned that he had legal incomes. He used to work for a company. You need to please take into account the fact that Platon has a family. He has 2 children that he is providing for, and he used to have other incomes also. Moreover, in that period, his wife used to work also. But please agree with me that I could not ask him where he got this money from. I was counting on the relationship that we had because he had been honest to myself and to the members of my family.
Okay. Well, Mr. Adam, we also noted in the notice of hearing that you had not disclosed in your declarations with NIA that you had made a loan to Mr. Platon. You also didn't disclose in your declarations any repayments by him of the loan or payments by him to the bank of the loan. Why did you not include that information in your declarations?
Mr. Chair, I would like to stipulate once again that the amount of money that I received in 2014 was mentioned in the asset declaration for the following years. These 400,000 years that I received based on this contract was mentioned in the declaration. Once again, this was a verbal agreement, and I did not need to conclude another agreement because we did not have a contract with Platon to give him the money. Moreover, I did not have any proceeds from giving the money to Andrei Platon.
Okay, let's turn to a different question related to disclosure. Mr. Adam, you'll perhaps recall that Issue 7 in our notice of hearing refers to you are not disclosing in your NIA declarations bank accounts with balances that exceeded 15 annual salaries. This was for 2022. There's a bank account that had 221,333 Moldovan lei. For 2021, the same account had 214,954 Moldovan lei. Now, in your answers to the commission, you told us that you had accidentally omitted disclosing these accounts in your declarations. But you also said that in your declaration for 2023, you had included the amount that exceeded the threshold of 15 salaries. So I'd like to ask you, I'm going to give you a copy of your declaration for 2023. Can you show me where you've identified the amount that exceeded the threshold for this particular bank account?
Desigur.
Yes, of course.
Domnule președinte, stimați membri,
Mr. Chair, dear members, I answered this question. Of course, I admit that each year in the asset declarations, I mentioned all the incomes I had for those years and for the members of my family. That means myself and my wife. We only had one income, the salary. Therefore, all the money was received in the bank account. The National Integrity Agency had all the declarations, they checked them, and they issued decisions on this, and they established that there were no violations. But I agree with you. Because we were a bit older, and it's more difficult for us to keep up with all the amendments in the laws. And I'd like to be honest with you and tell you that I used to receive the salary in my account. We didn't have many expenses in that period. My wife was working, I was working. I only have one child who is grown up. He has or she has their own income, so they have a salary to support themselves. And I tried to have savings, and all those savings were in the account. And I fully agree with you. The amounts in the accounts are beyond the threshold of 15 average salaries. And for 2023, I mentioned this in the answer declaration. And afterwards, this amount of 200,000 lei was placed on a separate account to have some means.
You said it was mentioned in the 2023 declaration. My question is simply this: where is it mentioned? Where is that bank account mentioned in your 2023 declaration?
This bank account
Well, Mr. Adam, we
Nu
just,
sunt sigur, domnul președinte, fiindcă eu în
I'm
perioada
not
respectivă am
sure,
avut
Mr.
posibilitatea,
Chair,
am avut
because
posibilitatea
in
să
that period,
discretă.
I had the possibility to amend it, but I can certainly say that it was mentioned in this declaration. I'm sure that the money.
and we'll double check. We'll double check to make sure that we're looking at your most current declaration for 2023. And I appreciate your looking at that for me. Let's turn to a different question. Issue 8 in the notice of hearing refers to the acquisition and sale of some property at the end of 2018 and in 2019. We've already talked a little bit about how your wife was a surety in 2014 for the loan that you took from the bank, and you've stated in your comments today earlier that you declared with your NIA declarations her income and your income. Appreciate those statements. On this matter, as you know, parcel of land was purchased at the end of 2018. In the summer of 2019, your wife sold that land. And we have questions because those transactions were not identified in your declarations for NIA. They weren't identified in your 2019 declarations. The contract for purchase and sale in the summer of 2019, when your wife sold the property, made a profit, that contract references a power of attorney. And I'm giving you a copy of the contract for sale and purchase. And you'll see on the very front page, there's a statement that she's entering the contract on her own behalf and on your behalf pursuant to the power of attorney. So my first question is, did you give your wife, as this document indicates, a power of attorney on the 5th of February, 2019? Did you give your wife a power of attorney?
Da, desigur.
Yes, of course.
Did you understand that the power of attorney related to the property?
Nu.
No.
What did you understand? Was it a general power of attorney?
Da.
Yes.
And why did you understand you were giving your wife a general power of attorney in February of 2019?
Domnule președinte, stimați membri,
Mr. Chair, honorable members, the house that is in Chișinău was purchased by my family in 2000.
respectiv, începând cu anul 2000,
Therefore, starting with 2000, we were allocated a land plot that used to be used by my parents-in-law as a place where they would grow different agricultural products. You could not build something on that plot because there were utilities for gas, sewage, and so on. So, in order to build something, you had to change some documents. Yes, I offered that general power of attorney in 2000. I did not know the cause. I found out about this contract from the round of questions. I did not sign this sale purchase contract, and I did not mention it in my asset declaration. Moreover, I do not deny the fact that there is such a power of attorney. I probably signed such a general power of attorney, but at that point I did not have ownership document on that plot. This is why, based on this power of attorney, this plot was privatized and it was sold. I tried to be correct and to indicate everything in my asset declarations.
So, with regard to your wife, you've said, you noted already that you did include her her income, her salary in your declarations. In 2019, in order to complete your declaration, did you ask her about her financial assets and transactions otherwise, other than the salary income she had?
Nu am întrebat.
No, I did not ask her. And as I was saying, I did not know about this until I received the questions from the Commission. And moreover, even if I had indicated it in the declaration, there would have been no problems, because by the fact that it was registered and sold, there were no damage to the government, something related to not paying taxes or an increase in the incomes of my family.
But taxes were never paid on the gain from the sale, correct?
Nici nu trebuiau plătit taxe.
There were no taxes to be paid.
There's also a question about your non-disclosure of your wife having the right to use some automobiles that were owned by her brother. You may note that it's item 10 in the notice of hearing. And there too you say you were unaware that your wife had those rights. I note that you've traveled with your wife in one of those cars, the Honda CR-V, across the border at least twice in 2022. Did the issue ever come up about how it was she had a car that she could travel abroad in? And
Desigur că sunt răspuns la asta, practic au fost rămas două răspunsuri.
Of course, basically there's two answers. It's the Lancet Mitsubishi car and the Toyota car. The first car belongs to my brother-in-law who bought it from abroad. Sometimes my wife used to use it. Later it was damaged and then sold by my brother-in-law. Then he bought a different car, and since he is working and he has a company car, my wife uses this second car. The owner is Platon Andrei. Both previously and now, I am using the car that I own. Basically, in the Republic of Moldova, we have this practice that you could use power of attorney or a mandate. I didn't know that my wife had such a mandate because I did not see the materials. I saw that request for that, and that later resulted in a commodatum from my brother-in-law. This commodatum was declared in the asset declaration when in November I was contacted and they told us, Mr. Adam, you did not mention commodatum agreement. So we identified this omission. I corrected this and I included the commodatum agreement in the asset declaration for 2023.
okay, then let me turn to a different topic, and this is issue 12 in our notice of hearing, In the ethics questionnaire, you may recall there was a question about prior actions. It's question number 5. Basically goes to disciplinary actions, allegations, and misconduct. So it's question 2 on the ethics questionnaire. You'll see, I've given you a copy of the ethics questionnaire. When you completed your ethics questionnaire, you left that particular question unanswered. You didn't check yes or no. And the concern the commission's identified is that you had been subject to a dismissal in 2007, later reversed. And then there also was some allegation later of misconduct in your role as a supervisor. And I just want to understand why you didn't answer the question in the ethics questionnaire.
Stimate domnule președinte, stimați membri.
Dear Chair, dear members,
Diligență, eu practic am răspuns la toate
I diligently answered all the questions that were asked, inclusively
corespundere cu prevederile legii, chestionarul.
in line with the provisions of the law. So this is how I filled in the ethics questionnaire. Regarding the termination of the work agreement in 2007, I can say that I've been working in the prosecution for 34 years, and for 20 years I have been in the leadership of the prosecutor's office. I used to work as a deputy helper for special mission, deputy prosecutor for Chișinău. I used to work at the Court of Appeal, and starting 2008 until 2022, I worked in the management of the General Prosecutor's Office, head of the department, deputy head of unit, and so on. I did not mention the events from 2007 in that question. Sometimes it's difficult to remember those actions from 2007. The dismissal decision from 2007. I was dismissed from the position of deputy prosecutor for Chișinău for strange reasons. There was a conflict in Chișinău. And I would like to say this with all responsibility. I was dismissed based on a decision of the top leadership of the country. I was deputy prosecutor of Chișinău, and according to the law on prosecutors, I was the leader of the other prosecutors in this area. I think that at the end of October there was an incident in one part of the capital. In one bar, there was an altercation between some employees of the law enforcement bodies, representatives of the security services and the Ministry of Interior. This altercation turned into a fight due to a girl, and they started using their fists. The one from the security service, since he was a master of sports, took the others outside, hit the person several times, and the other one used the gun. And this was reported to the Minister of Interior, then to the President. I was the person responsible. I was deputy prosecutor of Chișinău municipality. Each deputy prosecutor had one prosecutor's office in their responsibilities. In the morning, I am called and I am told, look what happened there. There was incident, and the Minister of Interior reports this further.
So let me, I'm a little confused, so let me
Just
just ask a
first,
question so, to make sure I understand you. Are you saying that you didn't answer the question because you couldn't remember, or are you saying that you didn't answer the question because you thought that to the extent there had been actions or allegations against you, they were not justified?
Nu au fost abuzivi.
These were abusive, unjustified. As a citizen of the Republic of Moldova and as a prosecutor, I consider that my rights had been trespassed. I challenged this in court, and through the decision of the 1st of April 2008, I was reinstated in my position. Then this decision was challenged by the Prosecutor General Office, who through the civil panel the decision was upheld. Then we had a writ of enforcement. So this decision to dismiss me was annulled and I was reinstated. So I was not obliged to mention this in the ethics questionnaire. Moreover, starting 2008, I was promoted and I held the positions that I mentioned, the head of department in the General Prosecutor's Office. And there was a competition. I won the competition 2 times. Moreover, this was not asked from me, not even when I submitted my application for the position of General Prosecutor. So I didn't mention it because I was reinstated in my position through a decision. And this means that the decision has no legal effects anymore.
Okay, let me turn then to the last issue that we've identified in the notice of hearing, and this is it's a very specific question about you buying a used Mercedes in 2020. You'll recall you bought it, and you've explained to the commission that you paid 297,000 Moldovan lei for it. The contract states that the sale price is 145,000, less than half the price that you've told us that you paid. And my question is, were you concerned at all about the sale contract identifying a price lower than the actual price? Did that give you any concern?
Yes, Mr. Chair, members of the Commission. Throughout these 3 rounds of questions, I tried to find out the answers and to mention this in the questions. And I'd like to explain this. In 2010, I purchased a car that I used throughout 10 years. Since it was in a bad state, I decided to purchase a new car. Through some persons, I think there was a parking lot near Metro where some cars were displayed for sale. So I thought that I would trade in this car, add some money, and buy a new car. They said, it's okay, I can give you an offer. And we started discussing how much do you think this car is worth. So I indicated 7,000 or 7,500 euros. Okay, so this is the price of the car. So we amicably decided that the price of the car is 15,000 euros. On the same day, on the 29th of February, I took a company from Micro Investor. They also had the notary public, and in 2 hours, we concluded this sale purchase contract. And then we saw that in the sale purchase contract, we have certain price. And I said, this car cannot cost that much. I have a certain position, and I asked how can I explain that the car costs like that, this amount, and this is mentioned in the contract? So I tried to comply with the legal provisions. And they said, we can proceed as follows. You can give us the car, and we can use this difference. So I contacted someone from this area. This is a late colleague of ours. And he said, this is not only your case. You can write in your declaration that there are two sources for this car. And I mentioned in 2021, 2022, 2023, 297,000 lei. This equals the price for the traded-in car and the money that I took as a loan. So these two equal the price of the car. Then the Commission asked, how come in February you took the car, but later you said that this is how much it is in the contract? When I took over the car, I left the keys, and probably in May, when the car was not on my name anymore, they paid for the owner, they paid the amount to the owner of the parking lot. Yes, I agree as a lawyer that I should have concluded this contract with the parking lot, and then they would have sold the car. But they said this is something that was used for everyone. And this is why we have this difference between the price that was indicated, but in the asset declaration, I mentioned the full price for the car.
Okay. Mr. Adam, I think I've asked you all the questions I wish to ask. Perhaps other commission members have follow-up questions or related questions? Okay. Seeing none, let me then ask you, is there anything you'd like to say by way of a brief statement before we conclude the hearing?
Nothing else to declare. Thank you very much for paying attention to me. I try to answer to your questions. I would tell you honestly, it's not so simple, it's not so easy, because when we talk about the ethics questionnaire, about the financial integrity, about calculations that I had to carry out for several periods during a lot of time, you have my answers in all the rounds of questions. I want to prove you for certain that I did not hide anything. Everything that I declared, there was here. If I had some omissions, it was not unintentional. And I want to tell you that in every proceeding, criminal or civil or administrative, or disciplinary, first of all, we need to prove the guilt. I try to provide the answers correctly and objectively, and to answer to all the questions. I would just kindly ask the Commission, when taking a decision, to consider what I've indicated in the answers submitted. And that's all from my side that I wanted to add and mention. Thank you.
Well, that brings us then to the end of today's hearing. Thank you again for your submissions and answers to the Commission's questions. After the hearing, the Commission will approve an evaluation report stating its conclusion whether the subject meets the criteria for ethical and financial integrity under Law Number 65. The Commission will strive to complete its report and announce its conclusion as soon as possible. It generally seeks to do so within a month after a subject's public hearing. This hearing is now closed. I wish everyone a good day. Thank you.
Mulțumesc.